This isn't just another court case. This is a repeat offender standing in front of a judge after decades of crime. We're talking thefts, robberies, and felony after felony stacking up since the 1980s. The court now has to decide, is this someone who can still change or someone who simply refuses to? And trust me, the judge's patience is about to be tested in a major way.
Good morning. Are you Veronica Randall?
It's Your Honor.
And Ms. Randall was previously in court in clause numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes.
This moment right here is critical. By pleading true to prior convictions, she's basically confirming her past, and that allows the court to upgrade the severity of this case. What could have been a lighter sentence is now legally pushed into much harsher territory. This is how repeat offenses come back to hit hard, and it's exactly why her exposure is now so serious.
The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yes, Your Honor.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate? No, Your Honor. No additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments.
Now this is where things get tense. The judge is acknowledging empathy, but immediately questioning credibility. And that's huge. In court, your word only matters if your history backs it up. When someone has a long record like this, trust becomes almost impossible. So ask yourself, if you were the judge, would you believe promises of change or rely on decades of behavior?
That she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. So I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yes, Your Honor.
All right, Mr. Vasquez, you may proceed with argument.
Your Honor.
The defense is making a last push here, trying to keep her out of prison completely. They're asking for probation, conditions, anything but incarceration. But here's the problem. She's already had those chances before, and they didn't work. So now the court has to weigh rehabilitation versus public safety. And honestly, with this track record, that's a tough sell.
I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition, and that the court thinks best would help her to quit offending. And in lieu of that, I mean, in the alternative, you're not asked for something less than the 6 years if she's going to.
Anything else, Ms. Malfini?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors that would enhance anything further. But if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report.
This is a turning point. The judge directly shuts down the idea that mental health is driving these crimes. Instead, he's pointing to a consistent pattern of choices over decades. That's powerful because it removes excuses and puts full responsibility back on the defendant. At this stage, the court isn't looking for reasons anymore. It's looking at results.
Some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986.
Let that sink in. Over a dozen felonies. At this level, the system sees a pattern that hasn't changed despite multiple interventions. This isn't a one-time mistake. This is a lifestyle of crime in the court's eyes. And when numbers get this high, judges often shift from giving chances to protecting society. The question now isn't if prison happens. It's how long.
A robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob, because I mean, we've got robbery, aggravated robbery, another robbery. Anyway, so at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25, DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. In cause number 26, DCCR 0312, find sufficient evidence to find you guilty and find all those counts true. And in that case, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0313, find sufficient evidence to find you guilty, find those prior counts true, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0314, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0315, find sufficient evidence to find you guilty and find all the prior convictions that you pled true to true. And at this time, find you guilty of theft of a firearm. Find those convictions true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0316, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated kidnapping. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same time. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Right, ma'am, you can go back with the bailiff.
Thank you.
And there it is, the final outcome. Multiple convictions, massive sentences, but all running concurrently, meaning she'll serve them at the same time. Still, we're talking decade behind bars. The judge followed the agreements but made it clear, enough is enough. This case shows exactly how repeated offenses can escalate into life-altering consequences. If you found this case as intense as we did, drop your thoughts below. Do you think the sentence was fair? Don't forget to like, share, and subscribe for more real courtroom breakdowns just like this.